People often treat a lawsuit like an open invitation to drag in every rumor, insult, side argument, and personal grievance. But litigation does not work that way. A court case has boundaries, and if something is outside those boundaries, it may not matter legally at all. I am Polymopicus, and this is Polymopicus Legal. Legal concepts explained for non-lawyers, by a non-lawyer for educational commentary, and is not legal advice.
When people hear the phrase, the four corners of litigation, they may think it sounds like a formal courtroom rule. This is not usually a formal doctrine. It is a practical shorthand for the boundaries of a lawsuit. Litigation is not supposed to be a free-for-all. It is not every argument between the parties. It is not every insult ever posted online. It is not every suspicion, theory, or dramatic accusation someone wants to drag into court. A lawsuit is controlled by its own legal frame that usually includes the pleadings, the claims, the defenses, the evidence, the court orders, and the rules of procedure. That is the box the case lives inside. The phrase borrows from the older legal idea of the four corners of a document. That means looking at what is actually inside a document, instead of inventing meaning from outside material. In litigation, the same general idea applies. The court asks, what claims were actually filed? What defenses were actually raised? What evidence is actually admissible? What issues are actually before the court? What orders actually control the parties? That matters because people outside the courtroom often think the loudest story wins. But courtroom decision-making is narrower than public storytelling. The court is not there to resolve every public argument. It is not there to validate every theory. It is not there to punish someone because a crowd thinks they are awful. The court is there to decide the legal dispute when properly placed before it. For example, if a complaint alleges breach of contract, the case is not automatically about every bad personality trait one side has. If a motion asks whether a pleading states a legal claim, the court is usually not holding a full trial on every fact in the universe. The question is narrower. What is inside the legal boundaries of this case? This is why pleadings matter. This is why evidence rules matter. This is why procedure matters. This is why court orders matter. They define the playing field. Once the playing field is defined, parties do not get to move the goalposts every time a new distraction appears. Sometimes outside facts can matter, especially if they relate to relevance, credibility, damages, intent, or another issue the rules recognize. But they have to be connected to a claim or defense, properly presented, and allowed under the rules, or they are just noise. A useful way to say it is this: the four corners of litigation are the legally relevant boundaries of the lawsuit. Inside those boundaries are the issues the court can actually decide. Outside those boundaries are arguments that may be dramatic, emotional, or entertaining, yet not legally controlling. That distinction is critical, because litigation is not just about having a story. Litigation is about having the right issue, in the right form, supported by the right evidence, presented under the right rules. Details that are outside the four corners of the case may be loud and also may not matter legally. Court is not where every grievance becomes a case. Court is where properly framed legal disputes get decided.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.